Is this any better?
No, I can hold the phone to my ear though.
Do you hear me, Tiffany?
Yes, barely,
Okay.
but yes.
This is case number 210785 LT, Curtis Gold versus Tiffany Claiborne. State your names for the record, please.
Curtis
Latif-
Gold. Sorry.
LaTiffany Claiborne.
This matter is scheduled for a landlord-tenant hearing this morning. Are the parties ready to proceed or have they reached an agreement?
We're
believe-
ready to proceed.
Okay.
Is there some question or issue?
Well, the only question that I have is we were waiting on this apartment complex that I'm moving in. They said I should have had an answer by the 18th. I called the lady yesterday. My credit report thing still hasn't came back. So I was gonna ask for an adjournment to the 24th is what I asked him last week and he said no. So I'm just really asking for adjournment to the 24th to get this other apartment.
Are you looking for an adjournment or are you looking for more time to move?
More time to move. So the lady said last week, asked for adjournment because by the 24th, we'll know if I got the place or not. Because we're just waiting on my credit report to come back.
Sir?
Yes. I can hear you.
Okay, but your response to her
Oh,
request for
well,
time to move.
which is, I can appreciate all that. The problem is if she doesn't get it, then she's going to want to stay longer. And that's where the problem comes in for me. So if there was a guarantee, if we had an end date guarantee, I would be fine. And that's why I was even fine with 14 days. But we don't, there's just still no end date guarantee.
Ms. Claiborne, the issue is that your landlord's only required to give you 10 days. And if you're talking about the 24th, 10 days actually puts us beyond that. The earliest he could apply for a writ of judgment entered this morning would be the 29th.
I had even said the 31st was fine, or the 1st was fine as well, which didn't make that much difference to me. The time that the extra few days to get everything straightened around was fine with me. It's just, I didn't want to go extend it past that. That's all.
So I asked before if you need to go to a breakout room and speak to one another. It sounds like you might just need to talk to come up with a move out date.
Well, that was the problem. He didn't want to go past April the 1st. So it wasn't anything else to talk about because he said he didn't want to go past the 1st.
What would be your?
Said, I won't know nothing until the hopefully before it was supposed to be by the 18th, but like I said, I talked to the lady yesterday and my credit report still hasn't came back. I'm trying to get out this apartment as soon as possible too because I have a mold problem and that's the whole thing. So it's not like I'm really trying to stay in his house and be here for free. I'm really trying to get up out of here.
What is an end date that you could live with, Tiffany?
Okay, so she said no later than the people moving out and they're getting the apartment ready and the credit report, I say no later than the 5th, I will be out of here.
Okay, so
that will give her time to get the apartment together and everything she needs to do.
I'd be glad to give you till the 5th. So if we could get it written up where you have till the 5th, that's fine with me. No problem at all.
I'm okay with that too.
Ms. Claiborne, you accept that?
Yes.
So your landlord's going to submit a judgment that you'll move by April the 5th, 2021?
Yes,
That's agreeable.
Yes,
And Ms. Claiborne, if Mr. Gold prepares it, is he authorized to sign your name to it?
you say what?
If he prepares a consent judgment, is there a mechanism for him to send it to you to sign?
Yeah, he could send it to me.
I can bring it to you, Tiffany, if you give me a date and a time.
You know, you slide it under the door, so you can slide it. I gotta be to the doctor's today, so we'll work on something for tomorrow.
Fair enough. We'll do it tomorrow.
I'll make a note in the file. The civil department will expect a consent judgment from you indicating that Ms. Claiborne will move by April the 5th.
Thank you very much.
Have a good day.
You do the same.
Thank you.
I have a question.
Ma'am,
Okay, so with the property, with the property having a mold problem that was here before I got here, do y'all make him fix this kind of stuff before he rents to somebody else? Because he knew it was a mold
Ms.
problem
Claiborne?
before he moved me in here.
Ms. Claiborne,
So
that's not what's before the court this morning. The sole thing
No, but
before the
I'm just
court,
asking, so how do I countersue?
ma'am, that's not what's before the court this morning. This is a termination
I'm-
pendency hearing.
I asked you a question. I said, how do I go
Ma'am?
about countersuing?
I can't give you legal advice. But when you receive your notice to appear to court this morning, there, you also received the phone number for Lakeshore Legal Aid and other legal resources. If you have questions about what to do, you can contact those persons.
That'll be fine,
Thank you. Have a good day.
as always.
Mr. Robinson,
How do you end?
Yes, Your
this
Honor.
shit?
were you ready with Ms. Seaborn?
I am, Your Honor.
How do
you hear me?
stop this video?
Very good.
Hello?
Ms. Seaborn,
Yes,
this is 210697 LT Green Metals versus Dazzling Seaborn.
This is Garrett Robinson on behalf of the plaintiff.
And ma'am, would you state your name for me, please?
that's Lucy Board.
This is the day and time set for hearing in this matter. It was originally scheduled for March the 10th, 2021. The defendant could not connect on Zoom. The parties have had an opportunity to speak this morning. How are we proceeding?
Your Honor, Ms. Seaborn is applying, it sounds like for Sarah funds through Wayne Metro. She started her into the application, and it sounds like the landlord should be receiving, my client should be receiving their end of the application. So in this case, I would ask that we adjourn to the 7th of April and see where we are then with those applications. I believe I have some other hearings with you at that time, at 9 on the 7th.
On the 7th, it won't be me. I'll ask Sandy whose docket that is. April 7th, 2021.
Yes, Your Honor.
Ma'am, you also wish to adjourn this matter?
Yes,
The matter will be adjourned to April 7th, 2021. The civil department will send a notice with the time, okay?
Great.
okay.
Thank
That will
you.
be Judge Green, Judge.
Judge Green, thank you much, Sandy.
I'm sorry, Your Honor, it looks like our calendar has that wrong, so.
Anything else as relates to Ms. Seaborn?
That is it for Ms. Seaborn. Thank you, Your Honor.
Okay, ma'am, you have a great day.
All right, you too.
Thank you. We're looking for the defendants for MIMG.
Your Honor, Ms. Peck in the breakout room. I should be back in the courtroom with me right now. And then also Dare Alagby, who is a co-tenant and defendant in this matter, did not appear at the pretrial and is not going to be here today as well. He's working apparently, according to Ms. Peck.
I see Ms. Peck is back. This is 210960LT MIMG versus Oldby and Peck.
Yes,
Your appearance, please.
John Burngrant for Gateway Townhomes.
Ma'am, your name again?
Portia Peck, defendants.
This matter was scheduled for the second hearing this morning. Parties have had an opportunity to speak. How are we proceeding this morning?
Your Honor, Ms. Peck is in agreement that her lease did expire on November 30th, 2020. The management office has permitted her to remain on a month-to-month basis. However, that was on the premise that she indicated she was moving out to a new house each and every month. We've gotten to a point now where she wants more time, and that was the reason that she scheduled this hearing in front of Your Honor, even though she understood what was going on and was willing to enter into a consent judgment. But again, she just wanted more time. So our position on this is that she's had plenty of time beyond November 30th. Her lease expired. And so we're seeking the entry of a consent judgment, which is essentially would get her through, I guess, the 29th before writ would issue on the 30th.
Ms. Peck, you heard the comments made by the attorney,
Yes, ma'am, I did.
and you wish to sign a consent judgment indicating that you'll move by March the 29th?
Your Honor, I am asking for an extension till the end of April, and that's because we're trying to close on the house. Due to the pandemic, a lot of things had just crop up, and again, because it's a loan where you would take and will be able to renovate the house. So there's a lot of paperwork going into work. So it's just been a whole lot. So I've been asking that this should be extended till the end of April, and then hope we'll be out definitely. I just wanted enough time because I'm with a preterm baby at home, and I don't want to be moving into a hotel. I mean, I've just been quarantined with my family for the longest, since I had my baby. So, and I just want to move from here, from point A to point B, and not just move to the hotel and then move to a house and all of that stuff. Why having a baby with me? That has to be in a certain environment.
Well, I'm sorry, ma'am. Did I misunderstand? I thought there was an agreement on a move-out date.
No, there was no agreement on a particular move-out date. So this was it. When my lease ended, they had asked me then, before my lease ended.
Ma'am, no. If there's no agreement.
No, because now I'm being charged month to month. So I did ask, I have some emails that I sent back and forth to give me an extension, but they didn't want to put it into paperwork. I do have a lengthy email. I kept going back and forth asking for an extension since I was being charged month to month. I really wanted to make it official, but Miss Gigi just would not.
Sir, I'm sorry, did I misunderstand you? I thought you said there was a consent judgment with a move-out date of March 29th.
Your Honor, we did agree to that. And then when it came time to learn that there would be another hearing date, which means today, Ms. Peck asked, then said, well, she'd like to ask Your Honor for more time. But we did have in our breakout originally a consent judgment. This morning, we don't have a consent judgment from the breakout room because she does want to ask for more time. What we have consented to is that, yes, she acknowledges that her lease expired in November. She acknowledges that she's been there each and every month and asked for more time. She also was unable to give me a closing date at our pretrial conference for her house. It's not been scheduled yet. So the manager from Gateway Townhomes should be here as well, somewhere on a Zoom. But yes, we did have a consent judgment at the pretrial conference until she learned. And then we went out to see Sandy, and then Sandy explained that we would be coming back for the following week to put the consent judgment on the record. And
there is a representative here from Gateway, Kathy McCoy. Do I need to bring her in? Do you need to go into a breakout room with the three of you?
Can we ask Kathy? Can she hear us at this point? If
She
that she
can't
feels,
hear us. I'm bringing her in right now. She's connecting right now.
okay, I'd like to ask her if she feels that would be more productive.
Ms. McCoy?
Hi.
Hi, this is a matter involving Oligby and Peck. Would it be helpful to go into a breakout room with your attorney and Ms. Peck?
Okay.
Okay, you're going to see an invitation, Ms. Peck. You're going to go back to the same breakout room number 2, okay?
Okay.
Thank you. Good morning, Mr. Rossetti.
You have to unmic your mic, James. Unmute. I'll come in there and try to unmute you.
Just let me pull these other people in from the waiting room and see if we can figure out if there are any other matches. Mr. St. Louis,
Yes, good morning, Your Honor.
good morning. What are you here for?
I'm here for the Harbor Club case.
It's Harbor Club versus Michael Magus. He's my client, or the manager of my client, Your Honor.
Thank you. Sit tight because that case is going to go at the end of the docket, okay?
Yep, no
Right,
worries.
thank
Thank you, Your Honor.
Thank you. Sir, that's connecting with the glasses and the other gentleman with the blue shirt. What case are you here for this morning?
Excuse me?
What case are you here for?
James Rossetti versus Jeff Nahovig.
And you are?
Jeff Nahovig.
Mr. Nahovig, your landlord is here. Do you need to speak with Mr. Speck and a breakout room before we proceed this morning?
I don't know if I do or not.
Your Honor, we're ready to proceed.
This is 210732, James Rossetti versus Jeffrey Nahovig. Your appearance, please.
For the record, Aaron Speck on behalf of the plaintiff, who's also present by Zoom this morning.
And your name again, sir?
Jeff Nahovig.
Matter was scheduled for an adjourned hearing and a landlord-tenant matter. Are the parties ready to proceed?
We're ready, Your Honor.
Mr. Nahovig, are you ready to proceed?
Yes.
Mr. Speck?
Thank you. Mr. Rossetti, would we swear the witnesses?
Mr. Nahovig, would you raise your right hand for me, please? Sir, do you swear or affirm the testimony you're giving this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
And Mr. Rossetti, too. I'll start with him.
Mr. Rossetti, do you swear or affirm the testimony you're giving this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Speck?
Yeah, Mr. Rossetti, would you state your name for us, please?
James Rossetti,
And your relationship to 29581 Ecorse Road?
the owner.
And you have an occupant in your home, a Jeffrey DeHovic, who's appearing by video today?
Yes,
Can you identify him, please?
Jeffrey Nahovic.
Okay, he's on the video, is that correct?
Yes,
Okay, do you have any kind of lease agreement with Mr. DeHovic?
the written one?
Any kind of lease agreement?
Not really.
Okay, he's just, is he an occupant in your home that you wish to have
Yes,
leave your home? Okay,
yes,
and you've asked him to leave?
yes,
You gave him a 30-day notice back some time ago?
yes.
All right. And is he occupying just a room in your home, or what part of the home is he occupying?
Just one bedroom out of 3.
Okay, this isn't like a group living set, this is a residential home, is that correct?
Yes,
He also has access to the remainder of the property, like the kitchen, a bathroom, that sort of thing?
yes,
All right, and you're asking the court to enter an order to have him removed within 10 days?
yes.
All right, I don't have anything further, Your Honor.
Mr. Nahavik, your response?
My response, Your Honor, Mr. Rossetti asked me to move into his home back in April, to help him out. I was awarded a Section 8 back in August, to where he has a home in Ecorse that he was going to get ready for me to fill the voucher, and the work never got done over there. So I'm in a situation, Your Honor, I really don't want to be where I'm at, but as far as my means right now, I'm trying my very best to find someplace else to go. I tried several places, with the COVID and everything going on. I applied at 3 different apartment complexes, and then I had Mr. Rossetti. I thought I was going to be able to move into that place. We had a verbal agreement with that, but I'm doing my very best to leave there. I do have, but I really don't want to have an eviction on my, for me to getting out of there and then trying to reapply for another Section 8, an eviction would not be good for me. And so,
Mr. Nahavik, I understand that, but the questions before the court are very limited.
I understand. I wanted to
Are
give
you, okay, do you acknowledge that you were served with a notice to quit indicating that you had to move by January 26, 2021?
Yeah, I wasn't sure if it was real or fake. I received it from Mr. Rossetti.
You broke up. You said you weren't sure if it was real because what?
Well, he served it to me personally, you know what I mean? So I wasn't sure if it was a hoax or not a hoax.
It's not a hoax, sir. And so you received this notice and you did not in fact move.
That is
Correct.
correct. I had no
You don't
means.
have a lease agreement or any other agreement with your landlord that would allow you to stay beyond the date provided on the notice.
No, but I have done a little research. I did talk to some legal aid, and they said that that I could have this dismissed, possibly. I don't. They told me to do a deed search, and what I've come up with is that Mr. Rossetti doesn't own the property, that Mr. John Stoplozik does.
You have proof of that this morning, sir?
Yes, I do. Now, that's the second page. This is the first page, Your Honor.
I can't, all I can see is it says County Register, Wayne County Register of Deeds, sir.
Yep, yep, from 2003. And the next page here shows right here that
You're-
Johnson.
I have to object. This is all hearsay.
Mr. Speck, I understand. And what I was going to say to you next, Mr. Nahavik, is that you have not supplied that information to the court.
I didn't know how to do that. I didn't know that if I had to supply that. This is something that I just received. Hello?
I'm here.
Okay.
But sir, the issue is that it was not raised previously. I'm looking in the file to see if there have been anything received from you regarding ownership of the property. And Mr. Speck, he is in fact raising it now, so I'm not taking the document in his hand as evidence, but do you have any documentation in your file that Mr. Rossetti in fact owns the property?
All I can take is his testimony. I can ask him when he purchased it. Mr. Rossetti, when did you purchase the property?
2002.
How long have you been continuous? Do you live at the property?
Yes, yes, sir.
Do you recognize the gentleman that the gentleman's name that Mr. Nahovic's referring to?
Yes, that was my stepfather.
Okay, and you bought the property from him?
Yes.
Okay, is he still alive?
No.
All right, I have nothing further, Your Honor.
Well, there seems to be an issue, but the court has not actually, well, there potentially was an issue, but the court hasn't received anything in writing from you. You have the sworn testimony of Mr. Rossetti that he owns this property. You acknowledge to the court that you received the notice to quit and have not vacated the property. You don't have any written agreement that allows you to stay in the property beyond the time provided in the notice to quit.
How can I get the court the paperwork? Can we have an adjournment to where I can get you this paperwork?
No, sir. I asked you, were you ready to proceed? And you said yes.
Well, but I don't know the operations. I'm not a lawyer. I'm just trying to do the very best I can to keep my head above water. And from what I understand, from what I understood is that,
Your Honor, we don't concede that anyone owns this other than Mr. Rossetti, but even if he is correct, my client has a prior superior possessory interest. Mr. Rossetti could evict just upon that basis, which we're not conceding, but he would be able to do that too.
Thank you, Mr. Speck. Mr. Nahavik, the court's going to grant judgment in favor of plaintiff at this time. Mr. Speck will submit a judgment to the court with a writ to issue date of Mr. Speck.
March 29th would be, actually, the 10 days falls on a Saturday, so 4 in the judgment will be through March 29th, and we can apply for an order to evict if he doesn't move by March 29th. I'll prepare it. Actually, I've already prepared a judgment.
If you'd submit it to the court, I'd appreciate it.
Okay, you want to email? I can't remember the last time I had one.
I think it's by email.
Email.
You can do
okay.
email, Judge.
Sandy says you can submit by email.
I can chat.
Supposed to be at 9:30.
I do. Somehow I am on my laptop. It was that Ms. Peck actually gave notice to the management office.
Have a baby. I can't start moving a baby into a hotel. She's preterm. This is the environment we've been used to. You understand? It's not advisable in the middle of a pandemic to start moving a baby into a hotel. Not for her kind of stage or the nature she is, the way she is. So we're just asking for just a little bit of time. And not that we are not owing anything on this apartment. We've been up to date. We've never owed anything on this apartment.
Ms.
Yes,
Peck,
Your Honor.
I'm asking if you have a defense to the complaint.
Okay, I probably didn't understand what that question means.
A defense. Did you receive a notice to quit from your landlord?
Okay, yes, I did, Your Honor. Yes, I did.
Indicating that you had to move by February 12, 2021.
Yes, Your Honor, I did receive that.
Did you in fact move?
No, Your Honor, I'm still in the apartment.
And you received the summons and complaint by posting back on February 26, 2021. Mr. Herman, do you need to speak to this defendant?
I'm happy to. I don't even know who she is in as much as she's not a named defendant, but I'm happy to speak to her. Judge Martin.
Oh, I'm sorry.
Nice to hear. It's nice to be able to say that.
I just had to pay the, yes.
Is Mr. Schaefer here?
No, he's at.
I'm not sure what, if I could go into a breakout room with her, I think that'd be helpful, Judge.
And you also have, Ms. Carter is here.
Carter,
Yes.
perfect. So when I'm done with Deanna's iPhone, whoever that is, I can come back in and I'll speak with Ms. Carter.
Thank you.
Okay, thanks, Judge.
Come on, sit down. Where are you going?
Ooh.
I pulled everyone in. There is no one in the court's waiting room at this time, so we can call the matters that are. This is 210734. J, your appearances, please. Valerie Guy. This matter was scheduled for 9 a.m. It is now 9:42 by the court's clock. Neither party has appeared. This is 210735.
Good morning, Your Honor. Carrie Side, P67390 on behalf of plaintiff.
Joseph Bowers. This matter was scheduled for 9 a.m. It's now 9:43 by the court's clock. There is no one in the virtual waiting room. Default shall enter in favor of plaintiff and against defendant.
160, so total rent retained, $2,800.
2,640 in rent, 160 in costs. Total retained possession is $2,800. Writ date of March 29th.
That's correct.
And you'll submit that default judgment to the court.
I will, Your Honor.
Thank you, ma'am. We're all set. Have a good day.
Thank you. Have a wonderful day too, Judge.
Thank you. Mr. Herman's in the breakout room. Two, Maple Leaf Gardens versus Vernon Glass.
Morning, Your Honor. For the record, Daniel Landman, P35797, on behalf of the plaintiff. I have not seen you for a long, long time. It's good to see you. Up to bigger and better things.
Thank you. There is no one in the court's virtual waiting room. This matter was scheduled for 9 a.m. It is now 9:44 by the court's clock. Defendant having failed to appear. Default judgment in favor of plaintiff and against defendant. Rent to retain possession.
$1,097.76, Your Honor, plus costs of $158.50. Possession judgment would be in the total amount of $1,256.26.
$1,097.76 in rent, $158.50 in costs for a total of $1,256.26. Plaintiff to submit the judgment. Thank you.
Thank you, Your Honor.
Next up is 210847 West Village versus Desiree Butler.
Once again, Your Honor, Daniel Land.
Now 9:45 by the court's clock. There's no one in the court's. Defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant. How much rent?
$6.27. Costs are $153.50. Therefore, the total possession judgment would be $1559.77. I would note, Your Honor, there is a CDC declaration on file.
Thank you, sir. I'll make that note on our file. Rent due of $1,406.27, cost of $153.50 for a total of $1,559.
Daniel Land for the plaintiff, Your Honor.
This matter was scheduled for 9 o'clock. There being no one in the court's virtual waiting room, defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant. Rent to retain possession.
Rent to retain, Your Honor, is $1,280 even. Costs are $153.50. Total judgment amount is $1,433.50. And Your Honor, I believe there is a CDC declaration for this file as well.
Thank you for the update. The court did not have notice of that. The rent to retain is $1,280, cost of $153.50 for a total of $1,433.50. Plaintiff will submit judgment to that effect. 210852 West Village versus Michelle Jones.
Daniel Landman for the plaintiff, Your Honor.
This matter was scheduled for 9 a.m. It's now 9:48 by the court's clock. There's no one in the court's virtual waiting room. Defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant. Rent to retain possession.
Rent to retain is $1,262.01. Costs are $153.50. Total judgment amount would be $1,415.51.
Rent due of $1,262.01, cost of $153.50 for a total of $1,415.51. Plaintiff's attorney to submit judgment to that effect. This is 210583 West Village versus David Jones. Counsel, I'll note your appearance for the record.
Thank you, Your Honor.
Matter was scheduled for 9 a.m. It's now 9:49 by the court's clock. There is no one in the court's virtual waiting room. Default judgment in favor of plaintiff and against defendant. Rent to retain possession.
607.21, Your Honor, with costs of $153.50. The total judgment amount is $760.71.
Rent to retain possession, 607.21, cost of $153.50 for a total of $760.71. Plaintiff's attorney will submit judgment to that effect. 210854 West Village versus Ann Marquette. I note your appearance for the record, counsel. This matter was scheduled at 9 o'clock. It's now 9:49 by the court's clock. There is no one in the court's virtual waiting room. There's a note on the file that the defendant did in fact file a CDC declaration form. He has failed to appear this morning. Default judgment shall enter in favor of plaintiff and against defendant. Rent to retain possession.
1281.45, Your Honor, with costs of $153.50, resulting in a total of $1434.95, and I acknowledge the existence of the CDC declaration.
Thank you. $1,281.45 for rent, $153.50 for cost, for a total of $1434.95. Plaintiff's attorney will submit judgment to that effect. 210858 LT West Village versus Joy Cassis and John Cassis. Plaintiff, I'll note your appearance for the record. There is no one in the court's virtual waiting room. Joy Cassis or John Cassis. This matter was scheduled for 9 a.m. It's now 9:50 by the court's clock. Neither defendant has appeared this morning. Default judgment will enter in favor of plaintiff and against both defendants. And to retain possession.
1407.68, Your Honor, with costs of $170, resulting in a total judgment amount of $1577.68.
$1,407.68 rent, $170 in cost for a total of $1,577.68. Plaintiff's attorney will submit judgment to that effect. 210860
You guys, put me on
West
hold or
Village
something
versus
so that-
Derek Forbes.
So I can't hear you.
Counsel, I note your appearance for the record. This matter was scheduled at 9 a.m. It's now 9:51 by the court's clock. There is no one in the court's virtual waiting room. Derek Forbes or Desiree McGowan. Defendants having failed to appear, default judgment will enter in favor of plaintiff and against both defendants. Rent to retain possession.
$1,186.78 plus costs of $170. The total judgment amount is $1,356.78.
$1,186.78 in rent, $170 in cost for a total of $1,356.78. Plaintiff's attorney will submit judgment to that effect. Is that the last file you have this morning,
I
sir?
have one other one, Your Honor, 210845, West Village versus Sandrea Bryant.
Ms. Bryant is here or was here. Ms. Bryant? He was here this morning at 8:48. She was here. I'm not sure.
Judge, I don't have a phone number, but if Mr. Landman does, I can give her a call and see if I can get a hold of her.
Your Honor, the property manager is present, Ms. Samples. Perhaps she has a.
Yep, give me 1 second. And I'll
If
look
you
it
don't
up.
mind muting yourself and reaching out to her. I know she was here earlier today.
Ms.
Okay,
Samples does have the phone number.
Thank you.
Judge,
Yes.
sorry, I hate to interrupt.
Nope.
Can you put Jasmine Carter and Parkwood into a break room with me? And then I'll come back and we can put Deanna's iPhone and that one on the record.
Thank you.
Yep.
Jasmine Carter and Parkwood are being sent to breakout room number 3 with you.
Thank you.
Mr. Lamon, other than that Bryant matter, would that conclude your matter?
It does, Your Honor, yes.
Thank you. Let's get back to 210950 Gateway versus Gibson.
Yes, Your Honor, John Bernkran for Gateway Townhomes.
I'm just double checking the court's waiting room. Again, this is 210950 LT Gateway versus Nether Gibson. This matter was scheduled for 9 o'clock. It's now 9:55 by the court's clock. There is no one in the court's virtual waiting room. Gibson, Nether Gibson. The defendant having failed to appear this morning, default judgment shall enter in favor of plaintiff and against defendant. Rent to retain possession.
$896 plus the court costs, which I compute to be $156, assuming the service fee is $26, Your Honor. Does the file reflect?
$37.
Oh, the service fee is 37. Okay, so that'd be
Yes.
167 then. Sorry.
Rent to retain possession of $896, cost of $167. Plaintiff's attorney will submit judgment to that effect.
Your Honor,
Yes.
I got a hold of Sandria Bryant. She's gonna pull off the side of the road and she will call back in just a few minutes.
Thank you. When I see her, I'll admit her, okay?
Thank you.
Thank you. 210952 Gateway versus Alexis Barnett. I'll note plaintiff's counsel's appearance this morning.
John Byrne, Cranford Gateway Townhomes, Your Honor.
Alexis Barnett. This matter was scheduled for 9 a.m. It's now 9:58 by the court's clock. There is no one in the court's virtual waiting room. Defendant having failed to appear, default judgment.
The amount owing, Your Honor, is $706 plus $167 in court costs.
$706 in rent, $167 in court costs. Plaintiff's attorney to submit judgment to that effect.
Thank you.
The last one I have for you is 210954 Gateway versus Tyler Brentley. This matter was scheduled for 9 a.m. It's now 9:57 by the court's clock.
Your Honor, Gateway Townhomes for the plaintiff landlord, the amount of rent owing as of today is $2,036 plus costs of $167.
Rent to retain possession, $2,036, $167 in court costs. Plaintiff's attorney to submit judgment to that effect. Does that conclude your docket with the court this morning, sir?
It does, Your Honor, and I do appreciate your patience.
No, I appreciate your patience, sir. Thank you very much, and you have a good day, okay?
Okay, thank you, Your Honor. You too.
Thank you.
Bye.
Well, I'm waiting for Mr. Herman to come back. Mr. Hitchcock, good morning to you, sir.
Good morning, Judge.
I am looking for your tenant. Is Sierra Cohen? Owen? This is 210961 LT Romulus Housing versus Sierra Cohen. Your appearance, please.
Steve Hitchcock, Your Honor, appearing on behalf of the Plaintiff Romulus Housing Commission, P15005.
Sierra Cohen. This matter was scheduled for 9 o'clock. It's now 9:58 a.m. by the court's clock. There is no one in the court's virtual waiting room. This matter was scheduled for a termination of tenancy hearing. Is there anyone else there? Notice was sent to the defendant, Sierra Cohen, on March 10th, 2021, directing her to appear in person this morning at 9 a.m. I've checked with the court officer. There is no one present this morning. Mr. Hitchcock. Your pleasure, sir.
This is for failure to recertify, which they have to do annually. It's both a HUD rule and it's in the lease also. And this tenant has failed to attend meetings that were scheduled for her recertification and or to provide any new information that is required to provide annually.
Based on the tenant's failure to appear, what's your pleasure, sir?
I'd like to have a judgment for eviction with March 29th as the date for move out.
Defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant with a move out date of March 29th, 2021. Plaintiff's attorney will submit a judgment to that effect. Actually, Mr. Hitchcock, there's a note from Sandy that states that the tenant gave you a CDC declaration.
I have not received that. And I don't think that that would apply anyway for her eviction for failure to comply with the lease terms. This is not a rent lease.
Correct. I'm saying it out loud. That's all.
Okay,
This is 21. Was there anything else as relates to Ms. Cohen?
no.
This is 210962 LT Romulus Housing versus Latoya Vinston. This matter was also scheduled at 9 a.m. It's now 9:59 by the court's clock. Is Latoya Vinston present? Mr. Hitchcock.
Mr. Honor, this is the same situation. It's a failure to participate in a recertification that's done annually. This tenant has not provided information or attended any meetings that were scheduled, and I would ask for a judgment with a writ for her to move out by March 29th.
This matter was scheduled for hearing this morning on plaintiff's complaint to recover possession of property. Notice was sent to the defendant on March the 10th, 2021, directing her to appear by Zoom. There is no one in the court's virtual waiting room. Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with a move-out date of March 29th, 2021. Plaintiff's attorney to submit judgment. Anything further for you this morning, Mr. Hitchcock?
Nothing further. Thank you, Judge.
Thank you, sir. Have a good day.
You too.
These are, thank you. I don't see Miss Bryant yet, so if you don't mind.
I'm here.
hanging around. Oh, Miss Bryant.
Yep, I'm here.
You. This is 210845 LT West Village Estates versus Sandria Bryant.
Good morning once again, Your Honor. Daniel Landman appearing on behalf of the plaintiff. Ms. Bryant is also present.
Yes, I'm here.
Did you need to speak to the attorney this morning?
Your Honor, at the first hearing, Ms. Bryant indicated that she would be moving by the end of the month. And if that is still the case, then I believe it would be appropriate for a possession judgment to enter, recognizing that Ms. Bryant is not going to bring her arrearage current before the end of the month. I would revise the move-out date from March 29th to March 31st, and I think we would be able to put this matter to bed.
Ms. Bryant, did you hear the comments made by the attorney this morning?
Yes.
And you're in agreement to move by March 31st?
Yes.
I would note, Your Honor, the rent to retain is $21,29.24 and costs are $153.50. So the total judgment amount would be $22,82.74. But because it's a possession judgment, Ms. Bryant would have the option of either paying that amount or moving by March 31st. And I know she has chosen the latter option.
Is this judgment going to be by consent?
Or after hearing, Your Honor, either way.
My lease is up, so I have to move anyway.
Ms. Bryant, do you have any defense to the non-payment of rent complaint?
I'm not able to basically afford it since I've been since this pandemic. So I've been trying to seek help to pay my rent. But also my lease is up too. So that's the reason why I have to move out, because I can't afford it.
When you say trying to seek help, have you actually applied with someone for financial assistance?
Yes.
And you're just waiting for a response, or what's going on?
Yeah, I'm just waiting for a response.
Who have you applied with?
DHS.
Mr. Landman?
Your Honor, obviously, if Ms. Bryant intended to stay, she certainly would have the ability to try to request some assistance, but I'm not sure how that would factor in to the point that her lease is up at the end of the month and she's planning on moving anyway.
Yeah, I don't have the option to stay. I received a letter from West Village Estate saying that my only option was to buy, and I can't even afford the rent. So I know I can't afford to buy it.
Ms. Bryant, do you have any dispute as to the balance of rent claim due of $2,129.24?
I did put in a deposit. So I'm looking forward to using some of my deposit money towards the rent that's actually due.
The security deposit is not an issue as of yet. This is the rent that's due right now.
Okay.
So again, do
But
you have any?
right now, I don't have nothing but that. I'm waiting to see if they can help help me, because I signed up for assistance in February. So I'm trying to see if they can help me with February or March rent.
Okay,
If not, I'll have to see if I could just use my security deposit towards my March rent and pay February.
I'm in a proceeding right now in the 34th.
Oh, Mr. Lamon. But again, Ms. Bryant, the issue is, do you have a defense to the rent that's claimed due and owing in the complaint?
No.
Okay.
I'm not saying I don't owe it. I know I do owe it.
There being no triable issue, judgment will enter in favor of plaintiff and against defendant. Mr. Lamon, if you will submit a judgment containing the numbers that you placed on the record.
I will do that, Your Honor, and I will also reflect the March 31st rather than March 29th move out date.
Thank you, sir.
Thank you, Your Honor. Have a
good day. Thank you for coming back on, Ms. Bryant.
No problem. Thank you.
Mr. Herman. No, he's not back yet. Mr. Zayed?
Morning, Your Honor.
Good
I'm
morning.
here. Sorry to interrupt you. I'm here on behalf of James E Management, a plaintiff versus Valerie Guy. I can give you a case number if you need it.
That'd be great.
All right.
Oh, wait, this is 210734?
Yes.
I called that case 20 minutes ago.
Oh, I apologize.
That's okay. 210734. Recalling 210734 LT JMZ Management versus Valerie Guy. This case was called at 9:42 a.m. No parties were present. Plaintiff's attorney is now present.
Good morning, Your Honor. Justin Zaid on behalf of JMZ Management. Your Honor, Ms. Guy did not appear for the last hearing, so it was my belief that she wasn't going to show up for this one either.
He has not been present this morning. There is no one in the court's virtual waiting room. Based on the defendant's failure to appear, default judgment will enter in favor of plaintiff and against defendant. The rent to retain possession?
$3,150 inclusive of court costs.
The rent without the court cost.
That would be $2,850.
$2,850 for rent.
Correct.
$300 in cost?
Yeah,
Yes,
yes, Your Honor.
thank you. Judgment shall enter accordingly. Plaintiff's attorney to submit the judgment to the court.
Thank you, Your Honor.
Thank you. Anything else, sir?
Just based on the last hearing, it's my understanding that the move-out date should be specified as the 31st, according to the moratorium.
Yes, sir. Thank you.
Thank you, Your Honor.
Have a good day.
You too.
Mr. Herman,
Yes, Judge.
did you have an opportunity to speak to Ms. Carter?
I did, and as well as the other case, which is 0829, and I'm ready to go on the record with both if you are.
I am. Give me 1 second to actually pull 210829 LT Parkwood Manor versus Donovan Sheffer.
Correct. Richard Herman on behalf of Parkwood Manor. Ms. Kedner, are you still here?
Yes.
You are. Perfect.
Yes, I'm here.
So Judge, I have found out that Ms. Kedner does,
Kegler, sorry.
Is it L-E-R?
Kegler.
Kegler. I am so sorry. Ms. Kegler is an appropriate party, so I would move orally to add her to the caption so that she can consent to this. So I would like,
Wait, Mr. Herman. The court does not have a copy of a lease in this matter.
of a
Anna
lease.
Kepler? Kegler, I'm sorry. Ms. Kegler? Are you an occupant or are you assigned tenant to this property?
I signed the lease with Mr. Schaefer. I've signed it every year since we've been here since 2012.
She is.
Do you have any objection to being added to this case?
No, ma'am.
So Judge, I would do a consent as to Ms. Kegler, a default as to Mr. Shepper.
And the terms of the consent will provide,
Rent to retain is $825. The total redemptive amount is $825. I have read Ms. Kegler her rights under the court rules. She did give me permission to sign her name. Am I correct, Ms. Kegler?
Yes.
and Ms. Kegler, you wish to consent that total rent due is $825?
Yes.
And again, you authorize Mr. Herman to sign your name to a consent judgment to that effect?
Yes, ma'am.
Inasmuch as the parties have appeared and consented to judgment in that amount, the court will sign it once Mr. Herman submits it, and the default shall enter as to Donovan Sheffer. Anything else in this matter, Mr. Herman?
Nope, I'm good. Thank you, Judge.
Thank you.
Ms.
Pam, you have a
Kegler,
good day.
you can go, and thank you for coming, and good luck to you.
All right, thank you.
Yes.
And this is 2108332 LT Parkwood Manor versus Jasmine Carter.
Richard Herman on behalf of the plaintiff. Ms. Carter, are you still here?
Yes, Jasmine Carter is the defendant.
So Judge, Ms. Carter and I have consented. Rent to retain is $3,653.27, 6353.27, with $154 in costs. So the total redemptive amount is 3817.00. The writ date is 3/29. I have read her rights under the court rule, and Ms. Carter has given me permission to sign her name as well.
Ms. Carter, you heard the comments made by the attorney this morning?
No, ma'am.
You didn't hear him just now?
Oh, pardon me. Did you say did I read the comments he made this morning?
No, I said, did you hear his comments this morning?
Just a few minutes ago as we
Yes,
spoke.
ma'am.
Yes.
And it's your desire to agree that rent due is $3,653
Yes,
and cost of $154?
yes, ma'am.
Judge, I think I might have made an error. It's 3653.27. 27 cents.
27 cents. That's your agreement, Ms. Carter?
Yes, ma'am.
And there have been $154 in costs.
Yes, ma'am.
So that means you're agreeing that a total of $3,807.27 is due and owing.
Yes, ma'am.
And you're authorizing the attorney to sign your name to a consent judgment to that effect.
Yes, ma'am.
Thank you. Mr. Herman will submit a consent judgment. I'll sign it. You'll get a copy from the court, okay?
Okay.
Anything else, Ms. Carter?
Thank you, Judge. Ms. Carter. I appreciate
yes.
it, Ms. Carter.
Hello?
Yes, ma'am.
Yes, the attorney did advise me if I had 3 days to ask permission if I felt that this case in any case needed to be ripped up or anything of that nature. I would like to ask permission for your contact information as a chance to contact you.
Can I chime in for 1 minute, Judge?
Hold on, Ms. Carter, to contact whom?
He said the judge. I'm assuming the judge is you.
I am the judge, but you don't contact me. You contact the civil department, and our court phone number is on the upper right-hand corner of your notice to appear this morning. But let's not wait. Let's not wait 3 days. You're here right now. Do you have some questions about what's happened this morning?
Yes, I do. Quite frankly, I did get assistance proactively. I just want to make it clear on the note that I have been in compliance with Parkwood as far as trying to come up with the funds that I owe. I did, as of yesterday, make arrangements to pay on a heavily portion on what I owe. I was told that $1,800 would be paid back on my expense. I'm not sure about additional funds as of yet. Yes.
You said $1,800 to be paid on your expense. I don't know what that means.
$1,800 going towards the debt that I owe towards Parkwood. I made out contact with one of the agencies that was stapled to my court order as a resource to getting help to pay back funds that I owe for my eviction.
Okay. Ms. Carter, when I asked you,
yes,
I asked you a moment ago, did you agree that this amount of rent is due? And you said yes. Okay.
Yes.
Then I asked you, did he have his permission to sign your name to that consent judgment? And you said yes, correct?
I did, correct.
And now you're saying that you might not be in agreement that that's how much rent is due, or is there something else?
Basically, what I'm saying is, sorry, Judge, I'm not fluent in legal matter or how the proceedings go very well.
That's
All
okay.
I know is, okay, so basically what I'm saying is I have, I'm having arrangements to make payments toward my debt.
Ms. Carter, do you have video available to you?
Do I have video?
Yes.
Oh, yes.
Can you turn your video on, please?
Oh, it's on.
Okay, here's my question.
Yes.
It's not the legal words that I need you to say. I need you to tell me in plain English, what are you saying about this $1,800?
What I'm saying is the attorney gave me a date of the 28th, right? As a way, or the 29th, as a way to make the full arrangements. What I'm saying is I'm making arrangements toward that debt now to pay. But also what I'm saying is I'm not exactly sure if I'm gonna have the whole 38. To the first meeting on the 10th, which was adjourned, it was specified that I had $2,600. prior to this court date today. So when I made the arrangements, I made it according to the 2,600. Now that the funds has changed, ma'am, that puts me in a dilemma. I don't know if the previous cost on the 10th was at notice to you prior, because the 10th was
Carter,
adjourned.
Are you reading from something?
No, ma'am. I'm just
Okay.
looking at my calendar date when I made my notes, so I can make sure that I'm telling it correctly. That's all.
Okay. See, this is where we are right now.
Okay.
I call the case. The attorney
Yes.
tells me that the parties have an agreement. So I put notes in the file that say, this is their agreement. He's going to sign it and send it to me. Then
Okay.
the very next thing out of your mouth is how to set it aside in 3 days, which rather than do that, I'd rather just talk to you this morning and make sure that we're all on the same page.
Okay.
And you're telling me that you had $2,600 and then you're getting
No,
assistance from somewhere else, or what is?
What I'm sorry. What I'm telling you is I made preparations to come up with the $2,600 to pay that amount. Now that we're in court today, the amount has changed, which I was not in preparedness for a price change. I just presumed that that we're having the official trial and that everything was going to be agreed upon what we had on the 10th, not to additional changes. I didn't want to be in non-compliance. So yes, I did agree, because also because I'm exactly not sure, by me saying no, am I not in compliance? I just want to be in compliance. I don't, however, I do have concerns. That's why I stated that.
Ms. Carter, then I need you to take a breath, because if you're saying that you don't want to agree, that you owe this money, that's fine. That means you have to have a hearing.
Okay.
And we can do that, but I have a 9 o'clock and a 10 o'clock hearing. So do you want to have a hearing, or do you want to have an agreement with Mr. Herman?
What? Okay, here. Okay, you gave me my two options. Whichever will put me in a position to state my disposition, ma'am. I just want to be able to be to come up with some funds in agreement that's comfortable for me to pay. I don't want to be on the streets with my kids.
May I ask a question, Judge?
Yes, Mr. Herman.
First of all, I'd like to make a comment. I'm not sure what this $2,600 is all about. When we started out today, she owed $900 more than what we ended up with, because much to her point, she indicated she had made 3 payments that we didn't have record of because there was a change in management. Parkwood, who you can see on the screen, went back and checked it and agreed with her. So we gave her credit for that. So she doesn't owe, she owes less than, not more. But Ms. Carter, I'm
Yes.
giving you till the 29th to come up with 3807.27. You said you're not sure that you can come up with that. What date do you need? What date do you need?
I get paid again, I believe. Do I get paid on the 20th?
Nobody wants to see you out on the street any more than you do. But the problem is
I get
you
paid
go
on
one or two more days, we're going to be in April and April's rent is due. And I don't want to put you further behind than you are now.
Right. I get paid again, I believe, on 24th of this month.
Okay.
So I can, shoot out some money on that day. Like I said, I made arrangements to have assistance of at least $1,800.
So how much money on the 24th?
No. We're going to stop for 1 second.
Okay.
Mr. Herman, I'm going to take your other two defaults. I'm going to put you all back in the breakout room because I do have other hearings.
Okay.
Okay, so this is 210831 Parkwood Manor versus Adrian Wilson.
Judge Richard Herman on behalf of Parkwood. Rent to retain by default is $1,142. with $154 in costs, totaling $12.96 even. Writ to issue on the 29th.
I'm sorry, Rick, this is Dawn. I
Yes.
do have monies here for Ms. Wilson and she has paid her balance.
Oh, she did. So this is dismissed.
Yes, I have money orders here this morning.
Perfect. Thank
So,
you so much.
Mr. Herman, you'll submit a dismissal on 210831.
I will, Judge.
Look forward to it. Thank you. And then 210833 LT Parkwood Manor versus Mark Riley.
Richard Herman on behalf of Parkwood. Did you get any monies on behalf of Mr. Riley today, Dawn?
I did not, no.
So rent to retain, Judge, by default is 4157.00 with 154 in costs. So the total amount is 4311 even, $4,311.00. 329 is the writ date.
This is 210833 LT Parkwood Manor versus Mark Riley. The matter was scheduled at 9 o'clock. It's now 10:27 by the court's clock. There is no one in the court's virtual waiting room. Mark Riley. Defendant having failed to appear this morning, plaintiff shall submit default judgment with rent to retain of $4,157, cost of $154 for a total of $4311. Mr. Herman, you can go back into that same breakout room.
One
number
second,
3
Judge.
with Ms.
I'm sorry. I'm so sorry. I don't mean to interrupt you, but I think I have another one on your docket. 0828, Portia Smith. Dawn, are we still good with Portia
So
Smith?
close. This is, you're right, Mr. Herman. This is 210828 LT Parkwood Manor versus Portia Smith. The matter was scheduled for 9 a.m. It's now 10:28 by the court's clock.
Judge,
Portia Smith. There had been a Portia here earlier.
yeah, it was a different one. That was
different one?
Burnkrantz.
Okay.
I noted that myself. It was spelled differently.
Matter was scheduled at 9. It's now 10:28 by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant. Rent to retain.
Is $200. I know. Well, rent to retain is 200, 154 in cost, so it's 354 total. I'm proud that she's gotten
I'll
down
wait
that.
default judgment with those numbers, and then you and Miss Carter can go back into a breakout room, okay?
I'm sorry, I did not hear the first part of your sentence.
I said I will note the file and await receipt of your default judgment with those amounts.
Thank you.
Thank you. And Miss Carter can go back into breakout room number 3 with you. I'm going to go off the record very briefly, and I will come back out and are the parties here on Airport versus Sunrise.
I'm here on behalf of the landlord. Believe the attorney is in the waiting room.
Good morning, Your Honor. Ian Bolton on behalf of the landlord.
I'm sorry, can you put Parkwood as well as Carter in the,
She could your client should be able to hit return to the breakout room and get
Okay.
back where she was before.
okay.
I see the attorney here for
Ms. Carter, you got to go.
Sunrise as well. And then I know that there's the Migas matter. I'm gonna go off the record very briefly. Don't go far. I'll be back in just a moment.
Thank you, Your Honor.
Dion, can you hear me?
Yes.
How are you first? So my client is here today, and if you give us 3 weeks to leave, he will leave in 3 weeks.
Wait, hold on. We're still, the judge can still hear us.
I'm gonna say the same thing with the judge if she can give us 3 weeks. And
Can we go into a breakout room and talk then real quick?
Okay. Well, after I have to say yes or no.
What's that?
Just the 3 weeks instead of 10 days. Just give him 3 weeks. Just because he have a lot of things to move, and that's it.
What about the money?
He's gonna try to arrange a payment plan after that.
Well, I want to agree to that as part of this if we can. Because I asked for a money judgment as well. I know it's capped at 25 and there's more than 25 owed, but.
I was saying you're gonna get the money judgment and you can collect after that. But meanwhile, if you just agree,
You'll stipulate to a money judgment as well then, up to the cap, the 25?
Yeah, we stipulate to the money judgment. Yes.
And all you want is 3 weeks as opposed to 10 days?
Yes.
Okay. Jennifer, any issue?
Let me call Aaron
Okay.
and run it by him. I'm guessing it's
I'll
gonna be
call you-
okay.
I'll call
Okay.
you offline.
Okay.
I'm gonna call you on your cell phone, so mute this.
Okay. Hello? I didn't think so. I'm a little technology challenged. Let me see if I can figure this out. There, it says I'm muted. I'll step outside. Okay, I'm gonna step outside then. Okay.
Team St. Louis.
This is 2-1. I'm sorry, Mr.
Judge, I
Robinson
think
and
this-
Mr. Migas.
I'm sorry, Judge, but I don't know if Ian Bolton and the other ones wanted to go into a breakout room.
We're close on a deal, Your Honor.
Do you want to go into a breakout room?
That'd be great.
Thank you, Sandy.
You're welcome.
Mr. Robinson, thank you for your eternal patience, and Mr. Migas as well. This is 2-1-0-7-0-6 Harbor Club versus Michael Migas.
Yes, Your Honor. Can you hear me?
I can hear you. Are you ready to proceed this morning?
Yes, Your Honor, I am. Thank you.
We adjourned this matter from last week because there were some questions and there was a defense, I think, that the defendant was trying to put forward regarding this non-payment of rent matter. Have the parties had an opportunity to speak this morning, or would that be beneficial?
I tried calling Mr. Migas a couple times earlier yesterday. If you would like, I would still like to talk, but so far our conversations have not yet been fruitful.
Mr. Migas, would it be helpful to go into a breakout room with Mr. Robinson?
That would be fine. Thank you, Your Honor. Thank you.
Mr. Migas, you'll see an invitation to go into breakout room number 1.
Thank you.
Thank you. I see that the parties are back in the Carter matter,
Yes, Judge.
recalling 210-832 LT Parkwood versus Jasmine Carter.
Richard Herman on behalf of Parkwood. Ms. Carter is here.
Yes, I'm here.
And Judge, we've had an opportunity to discuss this. We are in agreement by consent. Rent to retain is $36.53.27, 154 cost, $3807.27 to be paid on or before 3/29/21. I have read her rights under the court rule, as you're well aware of at this point. And she did confirm that I have her permission to sign her name.
Ms. Carter, did you hear the comments that the attorney just made regarding your discussions in the breakout room?
Yes, ma'am.
And you wish to agree to enter into a consent judgment that you will pay a total of $3,807.27 by March the 31st, 2021.
Yes, ma'am.
Understanding that Mr. Herman will sign your name and submit that judgment to the court.
Yes, ma'am.
When he sends it over, I'll sign it. The civil department will make a copy and mail it to you at the address we have on file, okay?
Okay.
Anything else? Any questions, Ms. Carter?
No, ma'am, not at this time.
Okay, ma'am, we're all set. You have a wonderful day. Mr. Herman, thank you very much. Good to see you. Have a good day.
Thank you, Judge. Likewise. Thank you, Ms. Carter. Be safe, okay?
Okay, you too.
Dawn, I'll see you.
I hate when you get to the end and there's a file left. That's never good. I'm just waiting for the parties to come back on either of the matters that are scheduled for hearing. That is not good. Oh, nope, here it is though.
Hi, Judge. Mr. St. Louis said he is here with Megas and Harbor.
Did you want to be in that breakout room with them?
Yes, please, Your Honor.
Thank you, Sandy.
You're welcome.
Yeah, we've had 9 kinds of fun this morning.
You said we have an extra file?
I said that, but that's not really true. It's not extra. I just had not taken the time to put the note in. There's no such thing as an extra file.
That's good. Thank you.
Don't be nervous. Yes.
I believe I was assigned to the wrong breakout room.
Oh, you were.
Thank you.
Thank you. So close yet so far away. Here we go.
I think Miss Jennifer is trying to talk.
Yeah, I was muted. I'm sorry. Could you put me in the breakout room with Mr. Bolton, please?
I will do that.
Thank you so much.
You're welcome.
Your Honor, I apologize again, but I'm not sure I was assigned to the correct breakout room. No one was in breakout room 2.
Mr. St. Louis, I'm just going to keep sending you invites and we'll see what happens.
I can be flexible, Your Honor, no problem.
I used to be able to multitask. I think those days have passed me now. But Mr. Robinson is back. Were you coming to get your client?
No, I talked to Mr. Megas, and I think he and I, well, I know he and I are both in agreement that we're not. He seems to, yes, he seemed to want something that I think is kind of beyond the scope of this case.
Then he's still in the breakout room. Let me get him back out here. Mr. Megas?
Yes, Your Honor.
Mr. Robinson has indicated to me that you have had an opportunity to speak and you don't have an agreement.
I'm trying to come up with one. Maybe you'll resolve it. I'm hoping. I know you're going to.
I am going to resolve it. I'm going to have you and whoever's going to testify on behalf of Harbor Club sworn in, but let me recall 210706 LT.
Morning, Your Honor. This is Garrett Robinson on behalf of the plaintiff.
Thank you. Mr. Megas, your name for the record, please.
It's Michael Joseph Megiz.
Megas, thank you. Are the parties ready to proceed to hearing this morning?
Yes, Your Honor, we're ready to proceed. I've got Mr. St. Louis here from Harbor Club to testify for my client.
Mr. St. Louis, would you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You put your hand down. Mr. Robinson, proceed.
Okay, please state your full name for the record.
Stephen St. Louis.
And Mr. St. Louis, please state your occupation.
Property manager.
And where are you employed?
Harbor Club.
How long have you been the manager there?
A year and 2 months.
And what does your job entail as manager at Harbor Club?
Managing a residential property of 1,000 units.
Are you responsible for collecting payments, leases, and repair requests from tenants?
Yes.
In what capacity, as manager of Harbor Club, are you familiar with Mr. Megiz and his tenancy at 48911 Denton Road, apartment number 203, Belleville, Michigan 48111?
I'm the
Sorry, in
property
what
manager.
capacity? Are you familiar with?
I'm familiar, yes.
Okay. Okay, do you have in front of you what has been marked as Plaintiff's Exhibit A?
I do.
Do you recognize this exhibit?
I do.
Please describe this exhibit.
Residential lease contract.
And who caused this document to be created?
It is a standard for occupancy by my employer.
And that is Harbor Club, correct?
That is correct.
Thank you. Were these records kept in the course of regularly conducted business of Harbor Club?
Yes.
And who signed the document? Who signed the lease?
Lauren Kleeman and Mr. Megiz.
Thank you. And who's Lauren Kleeman?
She's our community manager.
Okay, thank you. Your Honor, I believe I've established that this is a business document of my client, and I'd like to admit it into evidence.
Has a copy been provided to Mr. Megiz? I guess.
We did. Yeah, Mr. St. Louis had someone drop a copy of the lease agreement at Mr. Megiz's unit.
Sir, Mr. Megiz, did you have any objection to the court receiving the lease?
No, Your Honor.
It will be admitted. Thank you.
You're welcome.
When was the lease signed, Mr. St. Louis?
November 20th?
Mr. St. Louis.
Oh, I'm sorry.
October 28th, 2020.
Thank you. And when does the lease expire?
November the 19th, 2021.
Thank you. And pursuant to the lease, how much does the tenant owe each month in rent?
$1,180 in base rental charges.
Thank you. And also, just before moving on to a few questions unrelated to the lease, was there a rent, was there a prorated preliminary rental fee for when Mr. Megiz moved into the unit?
Yes.
And how much was that?
$432.67.
Thank you. So a few questions before moving on to the second exhibit. In the course of Mr. Megiz's application for residency, in his residency at Harbor Club, have you had interactions with him?
I have.
Thank you. Before the defendant became a resident, was he able to tour the premises in some way?
Virtually, yes.
Thank you. Could you describe the way that virtual tour took place?
It is a video tour that is walked through with a leasing agent at the property with Mr. Megiz.
And just to be clear, that video tour, is it of a is it a virtual representation, or is it an actual photographic walkthrough of a unit?
It's an actual video taken of a unit.
Thank you. And did the unit the defendant toured, in your opinion, closely resemble the unit that he was given?
It did.
Great, thank you. In what ways?
It is the same floor plan and same finish level.
Thank you. Since moving to Harbor Club, has defendant made any work orders?
He has.
I'm sorry. So I hear some conversation in the background. Thank you. I'm sorry, Mr. St. Louis, you were about to respond to the question about repair orders?
Sorry, yes, he has.
And can you relate to the court what happened in the most recent court order, work order?
The most recent order was a request put in for his dishwasher not draining.
Could you explain to the, is this the only work order that he's had related to the dishwasher?
It is not.
What has happened in a brief summary with the dishwasher in the work orders is made regarding the dishwasher in the past?
Absolutely. He has submitted 3 separate work orders. And the second work order, it was determined that the dishwasher needed to be replaced. So it was replaced. On his most recent work order, it was not draining due to eggshells and coffee grinds being in the disposal, backing up the plumbing system.
Has that work order been completed then? According?
Yes.
Okay. What other complaints has the defendant made about the unit besides the dishwasher?
He has indicated issues with the quality of drywall, the direction in which the refrigerator opens, as well as the faces on the drawers of the kitchen cabinets falling off, and the bathtub not holding water.
Okay, thank you. In general, then, do his complaints interfere with the habitability of the unit?
No.
Would you say that his complaints are more aesthetic then, and they don't prevent him from living healthily in the unit?
Yes.
Further, thank you. And did you offer any sort of accommodations to the defendant to address his concerns besides having maintenance fulfill his work orders?
I did.
In what ways did you make those accommodations?
Absolutely.
Or offer those accommodations?
Via electronic correspondence.
Sorry, I mean, what sort of accommodations did you offer?
Understood, sorry. He was provided with 3 different options. One was to submit all requested repairs, and we were to work with him through our maintenance team to get those repairs addressed. The other option was to transfer to a similar unit on the property should one be available. And the last option was to take advantage of our 30-day satisfaction guarantee, meaning he could terminate his lease and residency with no penalty.
Okay, thank you. Okay, could you, do you have in front of you what I have, what is submitted to the court as exhibit number, as exhibit B?
I do.
Thank you. Please describe this exhibit.
The residence ledger.
Thank you. Was the record, this ledger, made by a person with knowledge of, or made from information transmitted by a person with knowledge of the facts and events appearing in it?
Yes.
Was the record made at or near the time of the acts and events appearing in it?
Yes.
Is it regular practice for Harbor Club to make such records?
Yes.
Was this record kept in the course of regularly conducted business of Harbor Club?
Yes.
To what use does Harbor Club put these records?
Rent collections and account management for residents.
Thank you. Does this exhibit truthfully and accurately represent the amounts owed to Harbor Club and the payments made by Mr. Miguez as of March 5th, 2021, the last date on the ledger?
Yes, it does.
Thank you. Again, Your Honor, I would ask that this ledger be admitted into evidence.
I guess, have you received a copy of this ledger?
I'm sorry?
Did you receive a copy of the ledger from your
Yes,
landlord?
yes,
Do
it
you
was
have
on the
any
front.
objection to the court receiving it?
No, I don't.
It'll be received. Thank you, Mr. Robinson.
Thank you, Your Honor. Mr. St. Louis, when was the last time Mr. Miguez made a payment?
November 18th, 2020.
What was this payment for?
Move-in charges at the time of move-in.
Is it for move-in charges or was it for?
Excuse me, prorated rent. Yes.
Thank you. Has Mr. Miguez paid rent since that prorated rent?
He has not.
What money does he owe in addition to rent each month?
Utility charges.
And I don't believe I asked you earlier, but it's on the ledger as well. What is his his monthly rental fee?
Sorry, his monthly rental fee is $1,000.
Yes, how much is he charged for rent monthly?
In total, it would be
just per month first.
$1,240 in total charges.
In total charge, okay, including late fees and well.
Not including a late fee. It's $1,180 in base rental charges, $60 in utility charges, and should he pay his rent late, there is a $100 late fee assessed.
Okay, thank you, Mr. St. Louis. Since moving to Harbor Club, has Mr. Miguez made any payments save for that prorated rental payment?
He has not.
So how much is due in total with court costs?
$5,487.34.
Thank you. Did Harbor Club make demand for payment of past due rents to Mr. Miguez?
We did.
Has Harbor Club received payment from the defendant regarding these past due rents and costs?
We have not.
And what relief are you asking from this court today?
Judgment of possession for the rent owed.
Your Honor, those are all the questions I have for Mr. St. Louis.
Thank you. Mr. McGinnis, do you have any questions for Mr. St. Louis?
Any questions? If anything, Your Honor, I heard everything he said. And when I moved in, there was a ledger.
Sir?
I'm sorry.
You can testify, but do you have any questions for this witness?
No.
Okay. Thank you, Mr. St. Louis. Mr. Robinson, do you have any other
Your
witnesses?
Honor.
I'm sorry, I couldn't hear that last bit.
I said, do you have any other witnesses?
Mr. St. Louis is my only witness today, Your Honor.
Thank you. Mr. McGinnis, you may now testify if that's what you were inclined to do.
Yes, thank you, Your Honor. Your Honor, when I moved in, I received my keys, and I also was given a virtual tour. There was a list of items that he explained. The bathtub doesn't hold water. He went on with the handle on the refrigerator door. They shot drywall screws through the plastic vent. And all this stuff that they were supposed to do, as far as what I was told, they didn't deliver it. And with all these things, how long have I been here? And he knows all this stuff needs to be fixed. I didn't tell anybody they couldn't come in and fix it. The only thing they fixed was the dishwasher. The dishwasher held dirty water for a month and a half. It started to smell up my unit. And I told them from day one they needed to just replace it. I mean, I'm in the business myself, in the construction trade. And bottom line is, it's not rocket science. If you want to make a customer happy, don't heckle. Because what I asked them to do in the beginning, they had to do in the long run. They replaced it. Because when they fixed it and thought it was all fine and dandy, I went shopping, I came home, my kitchen was flooded. It gets interesting. It's comical, but it's really not funny. It's happening to me and a lot of other people. It's called being bamboozled. That honey, and boy, she's a sweet lady and everything, but boy, what they tell you you're gonna get, boy, that cruise just turned out to be a train wreck. Not the cruise I wanted to go on. And when I walked in the door, me and my son were so disappointed. Your Honor, it's 2021. I want to know why I got 60 thermostats in this house. Are you hearing? This was my grandmother had this kind of stuff. And they want this kind of money. I could have moved into one that doesn't have an upgrade, and they look a little bit nicer than this one. Actually, they got better faucets that, spray water out of them to clean. And just, but at any rate, I could go on and on and on with the but I have never had a problem paying rent. I've had money from day one, and he kind of forced me into going via email because he didn't want to talk on the phone. I tried to get a hold of the man for 5 days, and I talked to the receptionist, and they said, well, we're not allowed to talk to you anymore, Mr. Megas. It's all have to be done email. So I thought, well, wow, this is great because I don't email. I'm sure you remember I brought that up at the yeah.
I do.
And you're very nice about it. If he doesn't know, hey, that's beautiful. But what I do know is I like to be treated fairly. Now, I've been forced to download an app from Habitat to pay a bill online. Now, when I moved in, I just went and got myself a money order, and here's the money. Why couldn't I continue to do that? I wouldn't be late, but with all the problems that I've been having here, I don't think it's worth $1,180. I'm willing to pay my rent today in full. I have nothing else to say. If you can go on with this, I appreciate you listening.
Mr. Megas, I guess the issue from my perspective, the last time that we were here, you told me that you were in the trade and that the apartment did not have the upgrades that you've been promised. And I was expecting to hear or see something from you that showed that the apartment was uninhabitable or that your use of it had been diminished. And you said something just now about the age and quality of the thermostat. So my question to you in response would be, does the thermostat actually work and control the temperature in the unit?
Yeah, it does work and control the temperature of the unit, but with the door walls being really, really old and very hard to close and the seals and everything being broke on them, I got $300-400 electric bill going right out the window. And it's my fault. I apologize, but I didn't know it was going to be electric. And it is. So with it being all electric, it's just very, very costly because it's not energy sufficient. And from what I was told by Haneen, we were going from the drywalls, from the studs, drywall, everything. I can walk you to the unit right next door. It's right down to the studs. But they told me a different story. They told me it was being renovated and the guy above me said it caught on fire. And he was living in the lower unit. Well, I gave a gentleman my card. I may have brokered the deal on getting the drywall work done over there, but you know, that's how I operate. You know, I'm sorry.
No, you're fine. I want to hear it. And as to the dishwasher, was the dishwasher actually repaired?
The dishwasher was actually replaced, like I kind of mentioned from day one, because, you know, oh, and then on top of that, there's been 5 maintenance people that have come in here. And every one of them I asked about, hey, can you put the refrigerator door handle on the correct side? Can you? 5 of them. Not 1, not 2, but 5. The 5th one, he said, sir.
I would only have a minor objection here that I'd like to keep this to issues of habitability and not to broader issues of aesthetics.
I understand that, Mr. Robinson, and sometimes that distinction is different for us as attorneys versus a person living in the unit. If you don't mind, if Mr. Megas goes on just a little bit longer, because I hear him say that he has the rent, the money is not an issue, and he'll pay for where he lives, but he has some complaints as to some things that were promised and not delivered. And I'm waiting to hear those things. And I hear the dishwasher here, it was replaced. I hear the ventilation, it was replaced. I hear the thermostat is old, but it worked. And the refrigerator door. Is there anything else, Mr. Megas?
Yeah, you know, inside of the apartment walls were not painted. The ceiling was painted, but the walls didn't get painted. As a matter of fact, the day I moved in, they weren't even complete. You know, they weren't even done when I was moving in. And that's the truth. I'm not making it up. And I didn't even want to move in on the 20th. Honestly, I told them I'd move in on the 2nd, not to further this along, but, and they said, oh, well, you can move in on the 2nd. That's fine with us, but you still got to pay. Why would I want to do that? But the day I moved in and walked into this, there was still people in here, they hadn't even finished the job. I've got paint all over my mirror in the bathroom, and that hasn't been fixed. What my whole thing is, all these things that needed to be fixed, why haven't they been fixed? I've been here 5 months. I've asked from day one.
You're saying that there are still things.
Everything. The bathtub doesn't hold water. You know, the door hasn't been replaced. When I open up the refrigerator door, I like to open it from the kitchen, not the living room, because I got a stove and it's like you just open it, put your stuff in and close it. It's more of a, it's the truth. They put it on the wrong side. That hasn't been fixed. And Mr. St. Louis even addressed all these things. And all the things that have been addressed, nothing's been fixed, none of it. I've got issues with the bathroom door, the bifold door does not close.
It doesn't close, or it doesn't close all the way.
It doesn't close all the way. It stays open. It's cocked pretty well. It hits the trim. I've asked the maintenance people to fix this when they've been in here working on the dishwasher 6 times. You know, I don't know what it takes anymore. Today, you know, I just don't know what it takes. Normally, you know, 25 years ago, that would have been done like that. But today, I don't know. People look at you differently today. I don't know what it is. I mean, it's a simple question, you know, can you fix it? The last guy that was here said, I put in a 2-week notice. I go, the 2 weeks isn't up yet, is it? I guess it was, because he walked out, nothing else got done, but the dishwasher got replaced after, like I say, a month and a half. I don't have no problem paying my rent, Your Honor, but I just want to lay cost fines. If you would accept the money order from here on out, I'd be great with it, you know, and anytime the guy would like to make a phone call and answer it, I'd be more than happy to talk to him too. I'm not a hard guy to deal with. I just want a fair handshake. I feel like I've been taken advantage of by what I'm supposed to be moving into and what I moved into.
Anything else, sir?
No, ma'am, I'm done. Thank you, Your Honor.
Mr. Robinson, do you have any questions to Mr. Megas?
I do. I just have 2 questions for Mr. St. Louis first, if that's all right.
No, it's not all right.
Okay. Okay, Mr. Megas, have repairmen been out for your washer every time it's broken? Just yes or no?
Yes, sir. They came out.
And did Mr. St. Louis or Harbor Club in general make offers to you regarding alternative places to stay when you expressed dissatisfaction?
We already went over all that. Yeah, they did. But you know what? I had no option. I had
Just
to
yes or no?
Other places didn't look any better than this, sir. I'll tell you that. It's pathetic.
Yes or
On the
no?
other hand, yes, they did. But I'm in here now, but they have fixed nothing, sir, outside of the dishwasher. That's it. Thank you.
Your Honor, that's really it for me. Your Honor, Mr. Miguez has made no payments since prorated monthly payment for his first month last November. His complaints about the unit are primarily aesthetic. I understand that they are upsetting to him, but he's been offered multiple options to move before within the first 30 days of his residency or to receive a new unit. He's complained about things to be fixed, but has generally talked about paint and handles, which are things that again are do not affect the habitability of the apartment. So again, I would ask for judgment session on this matter.
Mr. McGinnis, any final words in this matter?
No, Your Honor. Thank you.
Thank you, sir. Mr. Robinson, I've listened to the testimony of the parties this morning, and the court indicated that it would receive a copy of the lease and the ledger. I don't have it in my file. I'm not sure if you previously submitted it to the civil department. At this time, the court is going to enter judgment in favor of plaintiff and against defendant. After hearing, and I will indicate that if there are any late fees that appear on the ledger and are included in the amount that you're claiming due, that those late fees be removed. It sounds as if there were an ongoing issue regarding some requested repairs to the unit. And I agree with Mr. Robinson that these did not affect the habitability of the unit, but they sound like more of an irritant to Mr. McGinnis. So Mr. Robinson, if you will submit a judgment after hearing that reflects what I just said regarding late fees, I will sign it. Anything else in this matter, Mr. Robinson?
No, Your Honor, thank you.
Anything else, Mr. McGinnis?
I just wanted to know if that would make it $4,720, Your Honor.
I'm sure Mr. St. Louis can answer that question.
Would you like me to answer it now, Your Honor?
If you have the answer, that'd be great.
I do. It's the updated amount would be $5,087.34, removing 4 late fees that were assessed.
Thank you, sir.
Thank you.
Did that answer your question?
Yes, ma'am, Your Honor.
Thank you. We're all set. Mr. Robinson will submit the judgment. I'll sign it, and the civil department will mail it to your attention.
All right, great. Thank you.
Thank you.
Your
Everyone have a
Honor.
good day.
You too.
Recalling Airport versus Sunrise 210730 LT.
Good morning, Your Honor. Haitham Al-Qudsi on behalf of the defendant.
Good morning, Your Honor. Ian Bolton on behalf of Airport Park Equities LLC, the landlord and plaintiff.
Thank you. Good morning, gentlemen. Good to see you again.
Good to see you.
You've been back in the breakout room. Were you able to reach a resolution, or are you ready to proceed this morning?
No, we have, my client will leave in 10 days and judgment is gonna be for $25,000.
Your Honor, I just want to make it clear for the record and on the consent judgment that the judgment is capped by the jurisdictional limits of the court. Plaintiff contends that more money is owed, and the parties reserve their rights to pursue that amount. And I'm sure defendant reserves its rights to defend against that amount.
Sure, Your Honor.
But the short answer to my questions is that there will be a consent judgment coming from the parties with a judgment of $25,000, further indication that the defendant is to pay or leave in 10 days.
Yes, Your Honor. Just to answer Mr. Ian, it's res judicata will not allow you to sue him again for this amount. So but we're not gonna discuss this now.
Wait, what's that?
The doctrine of res judicata will not allow you to sue my client again for the same case, so.
No, that's exactly the point I'm making. Is that this does not have res judicata effects with respect to the remaining amount owed.
This is not up to the judge. Once again, we're not gonna bother you with this. This is for the future.
It's
Well,
no bother. I'm
it's,
here. You have my undivided attention.
The judge needs to know whether or not we agree on the terms of the consent judgment. One of the terms I'm adding in the court further orders is that judgment amount represents jurisdictional limits, parties reserve rights regarding remaining amount due. Because what I don't want.
Let me ask it a different way, because it's 2021 and we do things electronically now. By Friday, will I have a document signed by both of you and or your respective clients that indicate that you resolved this matter, that you resolved this matter in its entirety?
I'm not agreeing to the. I'm only agreeing to the 25,000, Your Honor, which because I'm agreeing to the law. So,
Your Honor, the issue is that if they pay 25,000 hypothetically within 10 days, they're then going to argue that we don't owe the other $14,000 or $15,000, whatever the number is at this time. And obviously attorney fees keep ticking, but that's obviously not acceptable to my client. So we have this jurisdictional issue on the 25,000. It's 39,000 to retain possession. So I guess if we want to do that and do a money judgment for 25,000, and then we can reserve our rights on the money judgment issue.
That's you can do. One thing that's if you have 39,000, you said, to retain judgment possession.
Jennifer, what's the
$39,369.81. Also of note, there is a year left on the existing lease that Sunrise has signed.
Your Honor, I'll leave it up to you. My position is, we already spoke, there's gonna be 25,000. My client will leave in 10 days, and it's your call, Your Honor.
You don't leave it up to me. When I ask you, are you ready to proceed? And you both indicate to me that there's a consent judgment coming, but it doesn't sound like there's a consent judgment coming. And so I'll ask again, by Friday, so 2 days from now, 2.5 days from now, will I have a signed document from the two of you and or your respective clients that resolve the matters in this landlord-tenant matter?
Unfortunately, Your Honor, it sounds like no.
So we're having a hearing this morning is then my follow-up question.
We're prepared to move forward, Your Honor.
I don't believe we need a hearing, Your Honor, because it is what it is. The 25,000, we will agree to it. We never spoke about the extra money. He can put in a judgment, this is what we agree, that the plaintiff reserve his right to sue my client for additional damage or fee in the future, but we're gonna leave it like this, Your Honor. So like he said before, that we're just gonna put a step that the plaintiff might go after the client with any other remaining balance or damage done to the property. I can step to this, Ian. Mr. Bolton. I can step to this.
I guess I want to make sure I understood that for the record. You're acknowledging that that plaintiff is claiming that more than $25,000 is currently owed, and that plaintiff will or may pursue defendant for the difference between the $25,000 and what is currently owed, in addition to any future rent.
Yes, let's finish it.
A regular landlord-tenant judgment that says that defendant may be liable for damages to the property after vacation. I can't remember the exact language, but is that what the holdup is?
Yes, we will sign, Your Honor.
Well, it's not quite future. No. Just that provision, Your Honor, number 5 in the form judgment says the defendant may be liable for money damages after moving if additional rent is owed or if there's damage to the property. What I'm referring to is, I'm just not sure if that's clear, that it refers to the capped amount, right? Because the amount that's owing is more than the $25,000 cap. They're consenting to a money judgment, which is capped at 25,000. But the current amount owing is at 39,000, Jennifer, what is it, 39,387?
369.81.
So what I'm proposing, Your Honor, is to put that the amount owing is 39,369.81, but that the judgment amount is 25,000.
I'm sorry, Your Honor. One thing, we are agreeing to the 25,000 plus whatever there's additional money owns. One thing, this is more than enough. He can go after my client with the difference in cap in the future. So I am agreeing with him.
I guess I might be making this harder for myself than I need to. Do the two of you have an agreement as to how this matter will be resolved?
I'm sending you a draft consent judgment right now. So you can look at it and let the court know. Your Honor, is it okay if we
share screen?
Can you have another matter, or do you have anything?
No,
Can we?
you're
can I send-
it. I've noted my files while I was sitting here waiting for you two to answer the question. So let's do this. I'm going to make a note in the file. I'm going to make a note in the file that the parties have reached an agreement. I will send the file back down to the civil department. If you have not submitted a signed consent judgment with whatever particulars you want on there within a reasonable amount of time, Sandy will put it on a review docket, sends you notices to appear, and we can pick right back up here.
Thank you, Your Honor. Mr. Bolton, I will cooperate with you. If you send me something reasonable, I will sign it.
I'm
Okay.
gonna send you something right now.
All
As soon as I put in the attorney, I'm sending it to you.
Thank you.
Were you okay with how I propose we proceed, Mr. Bolton?
Your Honor, the only thing I would ask is, can we have a control date a week out, just in case? I don't want this one to linger too long.
I don't either, but I know what it's like when you send a proposed and somebody tweaks and then you tweak and tweak and tweak. And if I say a week is, I know it's not, I know we think we can do stuff in a week. That's not realistic. And I set a control date 2 weeks out. And if I don't have something from you, I'll have Sandy get you back in here.
All right, 2 weeks out, Your Honor. I
2
appreciate
weeks
it.
out. 2 weeks out with you, sir?
Yeah.
Good? Okay.
Yes, Your Honor. Hopefully we see you in a different case, Your Honor, not this one.
No, please come back. I like seeing the same case
No,
3 or
we'll
4
see you on a
times.
different case.
We'll set the review date for 2 weeks from today. Good luck with you hashing out the language. Anything else in this matter, Mr. Bolton?
No, Your Honor, I believe that's it.
Anything else on behalf of defendant?
No, Your Honor. Thank you very much.
Thank you. You all have